Hello, and welcome to Ipti Dixit, a podcast on legal scholarship. My name is Guy Hamilton Smith, the legal fellow for the Sex Offense Litigation and Policy Resource Center at the Mitchell Hamlin School of Law. My guests today are Drs. Alessandro Corda and Sarah Lageson. Dr. Corda is a lecturer at the Queen's University School of Law in Belfast, and Dr. Lageson is an assistant professor at the Rutgers School of Criminal Justice. Today, we'll be discussing their new article, Disordered Punishment, Workaround Technologies of Criminal Records Disclosure and the Rise of a New Penal Entrepreneurialism, which was recently published in the British Journal of Criminology. Alessandro and Sarah, thanks so much for joining me today.
Thanks for having us.
Thank you.
So again, as we had discussed, I was really interested in discussing this article with you because I think that what you are attempting to sort of unpack for a broader audience is something really important in a number of different respects. But so this paper discusses some of the different types of practices and the philosophies with respect to criminal records and criminal records management in both America and Europe. And so I thought a good starting point for listeners might be if you would be willing to discuss a little bit, what those practices and philosophies are and sort of where they diverge.
Absolutely, I can start. So historically, Europe and the United States have followed very different approaches when it comes to criminal records management and disclosure. The US have always been more open when it comes to disclosing criminal history information, while on the other hand, in Europe, criminal record information have always been treated as confidential, private, sensitive information. Until the advent of new technologies, even though you had these very different theoretical frameworks, in practice, things did not diverge too much. But then we know what happened in the US with the advent of technology, computerized databases, criminal history information were not just available on paper, but became really widespread also as a matter of practice. In Europe, they are still kept confidential for the most part, but then in this article, we try to shed light on some degree of convergence when it comes to the interference of technology with national rules or at times loopholes when it comes to the management of criminal history information.
Yeah, and that was, and we'll discuss that here in a moment, but it was also really fascinating to me, like the ways in which, private actors, I guess their ingenuity with respect to figuring out how to leverage different social policies and how to leverage different, different legislation to do sort of end runs around how the state was trying to manage criminal record data. But so a lot of your paper talks about, private actors being involved in criminal record management and dissemination. How did that arrangement, that public-private partnership, how did that begin? And are those interests in alignment with state governments?
I can speak to the U.S. policy. Criminal record policy in the United States, for the most part, actually originally had some privacy protections built in, meaning the official criminal record, which is a compilation of court records and police records and correctional records, that each state in the United States would have an office that would manage that information, figure out a way to match the identity of a person, and furnish this official record. And our research has shown that about half of the United States considers that criminal record to be a public record, and the other half of the United States considers that to be a private record. But even those states that consider it public maintain a degree of practical obscurity. So the requester of the record has to get permission of the subject, or they have to pay a fee. On the other hand, though, police data, court data, and some types of correctional data are not considered criminal records in the United States. So they're not governed by that policy structure. Instead, they're considered public records, originally designed for people to watch our government and to get information about the police or the courts. And a lot of that is built into the constitutional right to make sure that criminal proceedings are public and not private, and in theory, then delivered in a more equitable way. But as the digital turn took these public records and made them easier and easier to obtain in bulk, we've really seen this shift towards private actors sort of manipulating transparency laws and gathering all these different sources of criminal history information and then redisseminating them. The policy problem is that state regulations only for privacy in the United States only cover those compiled criminal history reports, where all these other forms of records, which are often pre-conviction records that can be problematic, those are just categorized differently. So the data is really widely available, and it's completely legal to redisseminate public records in the United States and to monetize them.
Mm-hmm. And so you use the term in the paper disordered punishment, and this seems like a natural time to kind of introduce that terminology and try to unpack it. So what do you all mean by disordered punishment, and why does it matter?
So I can speak to this point. The idea is that when we talk about dissemination of criminal history information, we categorize it under the label informal collateral consequences. And the idea of consequence communicates a sense of inevitability. But then as we see and the system on the ground, the way it works, we see that the dissemination and decision making in light of criminal history information is not as consistent as we might think. So basically, what is imposed as an additional punitive ramification of having a criminal record is not necessarily the predictable outcome, but it's very uneven when it comes to different attitudes of private decision makers towards risk aversion, but also when it comes to the completeness of records which are disclosed to private decision makers. There's also the issue of the legibility of criminal records compiled and disclosed by private actors. So in the end, we come up in the article with four fundamental characteristics of disorder punishment arising from the dissemination and disclosure of criminal history information. So disorder punishment means that the ramification of disclosing criminal records are unpredictable, unevenly imposed, disproportionate, and they can also be misleading.
Well, yeah, one thing that was really fascinating to me is the divergence of, I mean, you talk a little bit in the paper about how various state governments, that convictions can become, they can be expunged in the United States, or in Europe or in the United Kingdom, they can become spent. But that, so basically that those convictions no longer have any sort of probative value, but that consideration isn't really a consideration for private parties who are commodifying this data, monetizing it, and spreading it around. And so I just wondered if you all could talk about, talk about that tension a little bit, or if there's a way for state governments to, or what attempts that you've seen for, governments to try to, enforce the various considerations that they deem are important with criminal records, and try to enforce those on private parties, on like private actors, or can they?
It's been really difficult in the United States, and I think a lot of it's sort of an unintentional consequence of two parallel developments happening at the same time, which is the massive rise of the criminal justice system itself and mass punishment, mass probation, and states realizing that there needs to be a remedy at a certain point, that after people have served their time or paid their fees, or if their case was disposed in their favor, if their charges were dismissed, or they completed a probation that led to an eventual dismissal, that there needed to be another remedy available. So many states are adopting clean slate policies, expungement policies, record sealing. So that's sort of been one development. But at the same time, you've had the development that Alessandro and I really cover in this paper, which is the just massive disclosure of digital criminal records which are increasingly interesting to the public for reasons ranging from legitimate public safety concerns to extortion, entertainment, and bullying. So now we're at this point where, this sort of both of these trends kind of carried a momentum of their own, but it leaves a person with a record in a precarious position where they can receive the legal remedy of an expungement or their record being sealed, but that's really just a legal fiction. So they can walk into a courtroom, look at a judge and say, no, I've never been arrested, though they have. Now, when it comes to the First Amendment right to republish public records in the United States, that means that, as some courts have put it, the historical record of your arrest can still be publicized. You're not supposed to use that as a criminal history. It's just supposed to be sort of like the media coverage of said arrest or the archival record of such arrest. But for a person, they're stuck in a dilemma where they don't know how to tell another member of the public or an employer or a landlord which version of reality to report, right? Should they use their legal right to have a sealed record and claim to have never had a criminal record, while knowing that same person could Google their name or use one of these people search websites that we write about and then discover the record, making that person look like not only do they have a criminal record, but they're also lying about it. And so, there's been some efforts to try to regulate the background check industry that have been successful, or to force employers to really use only reputable search engine or reputable search companies to make an employment decision. But a lot of the legislation can't quite encompass just the internet, right? Google is sort of its own player in all of this.
No, absolutely. And so, you mentioned Google, and you talk in the paper, you talk a little bit about Google, which has been a bigger, this is obviously been a bigger issue in the EU as opposed to America, but, I think a lot of the same principles apply. So, I was wondering if you all could talk a little bit about right to be forgotten and what the implications of that are in this particular context when it comes to talking about, criminal records.
So, absolutely. The right to be forgotten is a 2014 case of the European Court of Justice. The case is called Google Spain. And basically, in this case, the court ruled that individuals have the right to ask search engines like Google to remove links with personal information about them. So this applies where information about a person are inaccurate, inadequate, irrelevant, or excessive for the purposes of the data processing. This is what the court ruled. In practice, the right to be forgotten allows individual to ask Google to delist search results for their name when it comes to what results are put forward by a search engine. And criminal history information make no exception in this case. The idea was really to give people a tool to prevent the rise of technology, of digital technology, from undermining rehabilitation schemes, expungement schemes, and so on and so forth. Because very easily, if you have been convicted, then you have been deemed rehabilitated, your record has been sealed, expunged, destroyed. You can technically and legally lie, but what if the information of your conviction resurfaces the internet after many years, many decades, because, for example, a print version of a journal has been meanwhile digitized, and if I type my name, even though I've been rehabilitated, that information, that piece of information resurfaces. The idea of the right to be forgotten when it comes to criminal history information is really to prevent this kind of situation. But it's really interesting that a tech giant like Google is now actively second-guessing policy determinations made at the national level when it comes to expungement sealing practices with regard to criminal records. Because we discovered that looking at their guidelines, publicly available on the internet, in regards to criminal history information, they say that generally speaking, they tend to weight in favor of determinations made by the courts at the national level. But then they actively add additional layers of scrutiny. Yes, a certain record has been expunged at the national level, but then they really want to take a look at the underlying facts. Okay, does this person pose a threat to the public? Is this person still dangerous? Yes or not, based on a certain person's current employment status, and so on and so forth. So we really see a tech giant second guessing sovereign states, sovereign governments, and their policies when it comes to expungement, sealing of criminal history information.
That was what was, I think, very surprising and a bit troubling for us when we did this research was to now really concretely understand that private players are not only aiding in the dissemination and essentially the creation of criminal records, but they're increasingly a strong player in the privacy side of records and the rehabilitation side of records. So our overarching argument in terms of technology companies is while they really are a major player in every single step of the criminal justice system here.
Mm-hmm. And so, and that was just really so fascinating to me, the way that you all unpack it in your paper, that you have these, tech giants and other private parties that are essentially, substituting their judgment in the stead of, what governments deem as important and appropriate. And so, do you see, what do you think the ultimate implications of that are? And is there a way to, I guess as the old saying goes, technology always evolves much faster than the law. And I guess in a lot of respects, that seems to be the case here as well. But what do you see as sort of the way, ways for governments to, reassert their ability to not just have those determinations entirely in the hands of private parties?
I think that because the law, like you said, the law may not capture this problem moving forward, but I have seen some courts in the United States start to use existing regulation and reinterpret it for a digital context. So ask more urgent questions about what constitutes a criminal record today. 30, 40 years ago, when these statutes were written, they were thinking about a single piece of paper. And so now I think it really is up to mostly appellate courts to think about how we should define a criminal history information in this day and age. So I think that will mean putting some layers of protection and rehabilitation and relief for people whose records are disclosed. So we saw a case in Pennsylvania where a bunch of mugshots were disclosed, and a judge in that case said, yeah, you know what, those are criminal records, and releasing them en masse was a violation of our criminal record statute that we wrote 40 years ago. And I think that the impact could be at the discretionary level for local criminal justice processing, because in the United States, this presumption towards openness really comes down to very idiosyncratic decision making by often county level officials, sometimes state level officials. So they can also reinterpret criminal history information in a more broadly encompassing way, so that they are regulating especially pre-conviction information differently. So we kind of turn down the leaky faucet of the bulk of information. So I think that there's sort of a couple ways that criminal justice actors, both the decision makers and then the judges that review cases where people feel that their information was disclosed improperly, that discretion might actually lead to a bit more privacy. I also think that local governments are starting to realize just how valuable all this data is. And for them to sort of give it away to these unregulated companies is really a disservice to them. They could be, treating this information as a more valuable resource, keeping it closer, and disclosing it only to those companies that are complying with federal regulations, just to sort of keep the whole process more clean. So I have some optimism that there might be some sort of local level changes that might assist people down the road. For the people whose information is already out there, they're really in a tough place, and we've seen people deploy all sorts of creative strategies to try to alter their Google search results, especially in the United States where they don't have the right to be forgotten.
And I think it's also very important to stress that, historically speaking, the government has always taken advantage of technological developments. But until recently, and that's still the case in many fields, basically the government works together alongside private players, taking advantage, as I said, of these technological developments. Private players partnering up with the government, working in a contractual relationship, have played a major role in the history of punishment, innovating methods of punishment. Private prisons, probation services, the role of technology in developing electronic monitoring, for example. And this is really kind of the penal entrepreneurialism version 1.0 that we describe in the paper. But then what happens in the criminal record space, it's something rather unique. And that's why we present this account of punishment entrepreneurialism version 2.0. Because all these private players, private companies, harvesting, collecting, disseminating criminal history information, and Google second guessing government policies and playing a role in what information are actually disclosed, they absolutely do not work side by side with the government in a public-private partnership. They basically exploit, make determinations about criminal history information the way they want. They profit off criminal history information, but they're not allowed to, they don't really work in partnership with the government. So the idea is really to regulate and try to recreate a sort of partnership and introduce some very firm boundaries and limits when it comes to the exploitation and use and dissemination and policing even online of criminal history information.
And so you brought up the idea, the penal entrepreneurialism 1.0 and 2.0, and in the paper you have some really fascinating examples of what that looks like, both in America and as well as in Europe. And I'm wondering if you can talk about those specific examples a little bit.
So Alessandro and I looked at two cases in the United States that sort of illustrate the public intrusion or the private intrusion into public records. And the first was looking at these people search public records aggregators. We specifically talk about a website called Instant Checkmate. And essentially what they do is they're not a regulated background check industry. Instead, they purchase public records, everything from birth records and marriage records, sometimes voting records, real estate records, and of course, criminal justice data. And they match all of them, combine them by integrating data based on a person's name, usually not the most sophisticated matching techniques. And then they charge users about $30 a month to come online and just have access to this bulk set of personal data about people. They say they're not a federally regulated background check company. They warn that you're not supposed to use this data for an employment verification, but instead they're just operating as a public service to make public records more easy to obtain. But of course, for people that are contained in that data, this means that there could be outdated, incorrect, incorrectly matched records that aren't even theirs, but they're still showing up on the internet. And these companies also advertise quite a bit. So if you search for somebody's name, often one of the first search results that comes up is for one of these people search engines or these public records information sources. A second thing that we analyzed is the intrusion of third-party software vendors into criminal justice processing. So we specifically looked at the case of the state of Colorado, and Colorado decided to digitize their electronic court docket. Many other states and counties need to digitize perhaps their jailhouse roster or their prison correctional supervision rosters. And in doing so, local governments don't have the technological resources to develop these massive database systems themselves. And so they contract with third-party software vendors who are really active in also promoting their technologies to these local agencies. But what the case of Colorado illustrated for us was Colorado contracted with a company, and this company was providing them with the electronic court docketing and court data services that the state needed, but the company was also duplicating the records and creating another version that they were selling to data brokers and to background check services on the other arm of their business. The problem was that there was confidential information like victims' names and social security numbers coming out through this data. But the point for us is that Colorado never intended for that to happen. They simply contracted with this third party to do their internal operations, and this company, once they legally obtained this data, they were free to go and use it in other ways. So Colorado really lost control of their criminal record data by virtue of needing to contract with a software vendor to do this sort of basic database work. So those are two ways that we saw sort of the intrusion of the market into what are supposed to be just government functions, thereby creating an even more vibrant marketplace for this kind of records. And as Alessandro can explain, we've in very recent years seen this sort of model now being exported to the EU, even though there are much stronger privacy protections in place.
Yeah, and I was really that was the other aspect of this paper that was so fascinating to me is just how this is played out in the EU and how you see this sort of private entrepreneurialism arise even within the context of countries that have much stronger protections around this data. So yeah, Alessandro, if you can explain that, that would be great.
Absolutely. So it's still true to this day that in Europe we have stronger protections when it comes to the privacy of criminal history information. But in this article, we talked about two outliers, if you will, the UK and Sweden when it comes to the involvement of penal entrepreneurs in the dissemination of criminal history information that in most European countries are not publicly available or made available by private parties. The UK example is particularly significant because here we are looking at a company which basically exploits the European integrated system, ECRIS, the European Criminal Record Information Exchange System, to obtain and disseminate information that could not otherwise be obtained at home in the UK. In the UK, there are three types of background checks: basic, standard, and enhanced. Once convictions resulting in a sentence below 4 years become spent after the passing or of preset amounts of time set by the law, they are not disclosed anymore. But then in this risk society, employers became eager to get information about spent convictions, even when they were not allowed to ask for this information nor to obtain that information. So they customarily asked applicants, we are talking about employers, landlords, to go to the police and request their own full criminal history record with spent, unspent convictions, and even intelligence information, if applicable, in order not to nullify the purpose of the Rehabilitation of Offenders Act. In 2014, the UK Parliament criminalized this so-called enforced subject access. So this company we identified basically after the concerned subject signs an authorization form, they file a request to obtain this person's criminal history information in Poland. Why? Because Poland is an EU member state, so pending Brexit, they can have a delocalized access to all the criminal history information of people residing in the United Kingdom. Of course, in Poland, there's no criminalization of enforced subject access. And so this exploitative use of the ECRIS system creates a backdoor to smuggle back into the UK information again that you could not otherwise obtain at home. So here we're talking about the idea of exploiting a system that was created for criminal justice agencies, police forces to exchange information and really to provide more information to public agencies. There was no idea of having any private players involved. But here we have a loophole. So once again, technology evolved faster, and regulators, legislatures have been kind of naive. So in this case, we really have a loophole to be fixed, and a private player that was very creative in finding a way to profit off this loophole. Then we have the Swedish example, which is in a sense very interesting, but a little bit simpler. Again, the advent of technology, the digitization of court records made available to private players information, pieces of information that could be purchased in bulk. And this was not really something that the state itself, the government, the court system was aware of. Apparently, Sweden has one of the oldest Freedom of Information Acts dating back to 1765, well before the US. And once court records were digitized, there was this company, Lexbase, that had this great idea to go all across the 48 district courts and purchase in bulk all the digitized information about convictions. And then they created a website, they developed an app, and they started selling criminal history information for very, very low fees. In Sweden, there were databases available charging very high fees, but only available to selected customers, journalists, members of the bar, but no one had ever sold criminal history information to the general public for a very low fee. And even when authorities tried to go after, to prosecute Lexbase, they basically realized that there was nothing preventing Lexbase from doing this. So once again, a loophole combined with technological development, and the government was just unprepared to deal with such a situation. And the website is still up and running.
And so, I mean, love is probably the wrong word to use, but I find it really, it's sort of inspiring, the level of creativity and ingenuity that people have gone to try to do end runs around, these sorts of protections. And so if this is like a sort of penal entrepreneurialism 2.0 in which we currently find ourselves, do you all think that there's going to be like a 3.0? Do you see this like continuing to evolve? Like, where do you see that kind of creativity and profit motive like going?
I think I fear that we may see an even bigger push to fold criminal record data into other types of big data and consumer data. So data commodities are the commodity of our time, and they're increasingly valuable. And I think the more complex a data broker can make a person's profile, the more they can sell it for. And so I do worry about sort of the total takeover of criminal record data to be used as a mark of a person's worth or character or morality, to use it to predict other types of consumer behavior. We've already seen, a big turn towards risk assessments and algorithmic justice, and that's happened at a speed that is troubling because we often don't question the integrity of the data that's being used for all these inputs. So I do worry that we're going to see just a entrenchment and an even stronger belief of the validity and usefulness of criminal history information in many other domains of life. But at the same time, Americans at least are starting to awaken to their privacy rights. And so we're also seeing state level right to be forgotten legislation, class action lawsuits against data breaches. So this could also be a time of revitalizing people's rights, and I think a call to actually center privacy as a fundamental right in the United States, just as it's framed as a fundamental right in Europe.
Mm-hmm.
Absolutely, I second this. And as someone recently said, privacy is the new celebrity. So as Sarah said, I really think that there's going to be a push towards getting privacy back as much as possible. And really the cultural shift, not just the policy shift, should really to start considering and then looking at criminal history information as a very sensitive piece of information, not just something that can be thrown into the mix of big data to profile people alongside other information. Criminal records, criminal history information are different. And it's fascinating to see that in Europe, of course, and now increasingly in US jurisdiction, you have sunset provisions when it comes to the relevance of criminal history information at the sentencing stage, the criminal history score. So after some time, an old conviction doesn't count any longer when it comes to the enhancement of a punishment for a newly committed crime. But then when it comes to criminal record, no matter how old the criminal record is, many times private players do not update their databases, or as we said, expunged records can resurface the internet if we don't have an actively implemented and enforced right to be forgotten. Basically, criminal history information is treated outside of the criminal justice system way more freely than they are within the criminal justice system. So I think that we should really try to reestablish this criminal history information exceptionalism also when it comes to big data and the life of these records outside of the criminal justice system, and accordingly consistently reducing access by third party to this information.
Mm-hmm. And so in closing, I have one thing that kind of kept popping into my mind when I was reading your paper. There's the distinction in philosophy between America and Europe in terms of what these records are for. But, with this penal entrepreneurialism, there's almost been a sort of a market force, you might say, that's been exporting the American philosophy of, right to know versus, right to be forgotten. And I'm wondering if you all have any thoughts about, what are the forces that are underlying this expansion of, or this exportation of, penal entrepreneurialism across, not only in the United States, but also in places where it hadn't been seen before?
I think that criminal records work as a very powerful proxy for people in a time of social insecurity. That's certainly been the case in the United States. And for many people, it's a much more quote unquote objective way to sort people as being part of society or not deserving to be part of society. And so as we kind of are seeing this populism wave and people being extremely fearful of the other, taken to new heights, maybe perhaps because of the way that we talk to each other on the internet instead of in person. I think that criminal records become a very strong tool that people can use to legitimate discrimination and to legitimate othering people. And so I do think it's part of a broader zeitgeist, and with the unfortunate quality that because it is a government record, people take it quite seriously without understanding the origins and the meaning of it. So unfortunately, I do see criminal records having the potential to be sort of swept in this broader global conversation about the other and about how we're treating each other.
I absolutely agree. I think that these private players, they really took advantage of the idea of risk aversion, risk society, and they really brought practices and business models in regard to criminal records to a next level. As we write in the paper, it's not just about risk aversion, but it's also about pop culture, gossip. So the purpose of accessing criminal history information is not just about background check for employment purposes. It's also about checking on your date, on your neighbor. It's really kind of a multi-purpose industry now. It's not necessarily just for the usual suspects, employers, parents when they have to hire a babysitter, and so on and so forth. So you have this narrative about risk prevention, but you also have, again, this commodification on what might be perceived as a lighter side, but then is just as harmful as the risk aversion narrative is when it comes to disclosing and disseminating this information.
Well, again, Sarah and Alessandro, thank you so much for your work, and thank you for joining me today.
Oh, thank you so much.
Thank you so much, Guy.
Of a reason, this is a case when your shoes don't need a shine. Give me some space, man, to practice my profession. I've got the ace, man, and what is yours is mine. In theory, yes, I abhor the violence. In practice, well, sometimes they freak. You honor me, I feel unique. It's National Crime Awareness Week. You honor me, I feel unique. It's National Crime Awareness Week. I'll put it to you this way, I love big chances. I'll put it to you this way, I'm a happy, happy guy. I'll put it to you this way, I love little headlines. Unknown Caucasian strikes one more time. So don't say a word, just hand me the Timex. I've got places to go and people to meet. You honor me, I feel unique. It's National Crime Awareness Week. You honor me, I feel unique. It's National Crime Awareness Week. You honor me, I feel unique. It's National Crime Awareness Week. Waiting for the music, the curtain drawn back, the water turning red. Don't blame that on me, I ain't no Tony Perkins.